All right, next we have Craig Dorne. And Craig Dorne has been involved with MS Views and News for quite some time. I've known Craig since I think I was first diagnosed. I mean, it's a long time, but we found that Craig brings a conversation to the table that is very beneficial for caregivers. So, I wanted to make sure that we have him around to speak with you all about that, and just some things for you to know about Craig. He's obviously he's an attorney. He's got degrees in bachelor's in business administration and Juris Doctorate from the University of Miami. God, another one from Miami. Canes. All right. His position, he's licensed in the state of Florida for 27 years as an attorney, affiliated with the Florida Bar and the American Bar Association. He's just a great guy overall, but I'm going to keep reading. Craig Dorne's an attorney licensed to practice in all Florida state courts, as well as the United States District Court for the Southern District of Florida. He has been licensed for over 25 years and has his own legal practice, which includes corporate real estate and health law, as well as commercial litigation, wills, and trusts. In addition to the full-time practice of law, he's an adjunct professor for the University of Miami. Let's welcome Craig Dorne. Thank you.
Good evening, everybody. It's a pleasure to be here, knowing Stuart for so many years and actually helping him form MS Views and News back in the early ages. As Stuart said, I'm an attorney. I'm here to discuss what many people really do not want to talk about, think about, and really need to have a true understanding of, because all too many people sit down and start executing documents not really knowing what they're signing. And too many people also don't sign documents that they really need to have signed and end up having people making decisions for them that they really don't want to have make those decisions. What we really need to do is, as a patient, for the people that actually have MS, as well as any other type of disease, is have an understanding of who is the best person to pick to take care of certain decisions for them. And understand that many times you really need to have more than one person making decisions for you. Like, one person might be very good at handling your financial issues, but another person might be good in making your medical decisions for you. So make sure you choose the person that you want to have and not have a court or somebody else make a decision for you. I've had too many patients that have come my way that I've actually had to refer to people because they're no longer capable of making that decision at a certain point in time. I've had people come to me saying, we need to make decisions for mom and dad. Well, how do I really know what mom and dad want to do? And sometimes mom and dad aren't capable of making those decisions anymore. So we actually have to go and actually have a court proceeding initiated to have a guardianship established for the person. Whereas if people do things at the front end, well, even though they may not want to think about it, it's really the best time to do it. The best example I can give you is how I learned about this the very first time. I started practicing law over 25 years ago, and I was practicing in a large law firm where I like to say I was number 326 on the list of lawyers outside of the firm. And I had one of the people that was really involved in wills and trusts call me into a meeting in their office and started asking me a whole bunch of questions. And I'm saying, who is this person? And being a young lawyer, you're kind of afraid to start asking questions. Why are you asking me these questions? And we went through a whole laundry list of questions. And then at the end of the conversation, she says, well, I'd like to sit down and have an appointment with you and your wife to come into the firm and now sign your will. Because she found as having a casual conversation was the best way to get somebody, like a better way of saying, off their butt to make decisions. Because at that point in time, I guess I was already married, I had 2 children, and I think I'm immune from everything. I'm invincible. The truth of the matter is, I realize, especially now that I've gotten a little bit older, I am not invincible. But we want to have the people make the decisions, meaning us, not somebody else. Or when you're married and you have children and saying, well, whose parents is it going to be, or whose brother or sister is it going to be? We have the decisions that are simple for people, but they get to be a lot more complex once you start having a medical ailment. As I say, when you make these decisions, you really want to choose wisely. Who is the person that you know? Maybe your spouse, maybe your best friend, maybe your children, but that person that will actually do what it is that you want. All too frequently, it's and say, okay, I want my spouse. Well, the example I like to give is best always talk about people that you know. Well, I happen to have a father who would sit down and never comply with my mother's decisions. So is my mother going to sit down and make my father the healthcare surrogate? And the answer is no. And it doesn't have to be. The mere fact that this person is your spouse doesn't mean that that person has to control every aspect. You can actually create a healthcare surrogate form and sit down and have the person that you want make the decisions versus the other. Then we can sit down and have the person who might be great in making the medical decisions, but is the world's worst with your money. You have the ability to separate and divide out these roles, and I'm going to start going over a lot of the documents with you to say, okay, this person does this and this person does that, and it doesn't have to be the same person. When it comes to being the person that's going to be your healthcare surrogate, it'd also be great to have somebody that has at least a little bit of medical knowledge. Because part of what it's going to be doing is, unfortunately, fighting with your insurance company, fighting with those explanation of benefits and the bills that might be coming in. You can sit down and give those powers as well to sit down and have the ability to sit down and fight those fights for you. Also understanding what your rights are. Dealing with patient dignity. Dealing with issues of making sure that there's getting fair treatment regardless of race, religion, sexual preferences, or whatever else it is. We have the ability to sit down and fight those fights for you as well. You can fight them yourself, or you can have somebody do it for you. Making informed decisions over your health care, and also even understanding what are the documents that you want to sit down and have completed for such things as organ donation and everything else that you sit down and do. Let's jump over here. Now, when you're now the patient, but you're the caregiver, understanding what your rights are. It's hard to understand, but you're saying you may be the person's spouse, but you may have no rights. The doctors may say, who is the healthcare surrogate? Where are your forms? Where are your papers? The problem you have is you don't want to sit down and have to worry about those things when you're being admitted to the hospital, when you're not competent to make those medical decisions. Get the forms done. And one of the things I'm going to tell you as you get towards the end of this is how you can actually get some of these forms and not have to hire somebody like me. You can actually get a lot of these things done for free. Because the caregiver has no rights unless those rights are actually given to them by the patient. As I started talking about the beginning, the thing that hurts me the most is when I sit down and I'm getting contacted by patients and their parents, their friends, their relatives are no longer competent to make the decision. And they come to me saying, I need to get a power of attorney form. I need to be able to take care of whoever else it is. And I'm saying, great, bring that person in. Well, I can't bring that person in, they're too ill. Well, if a person is incompetent, they can't sign that power of attorney form. So at that point in time, I have to tell them, you have to go to a state attorney and actually open up the equivalent, what we call a court-appointed guardianship. That means you're going to have medical expert testimony and a bunch of other things saying that this person is no longer competent to make their decisions. Needless to say, that's a very expensive proceeding. It's a very difficult thing to be done, and it also takes time. What happens with all the bills that need to get paid? What happens with all the medical decisions that need to be taken care of at the point of the time when the person can't do it themselves? You're going to be asking somebody to sit down and start paying the bills for you. Not out of your account, but out of their own account. Then going back to the court and getting permission to get paid back. Well, we can create basic documents, understanding what those documents are, to sit down and take care of those issues for you in advance. And as I said, many of these things can be done without even actually hiring an attorney. Now, understanding also that once you become the caregiver, you're assuming those responsibilities. There does create an obligation to you to make sure that things are done right, correctly account for those things, because once you assume that responsibility, if somebody else comes down the road saying, well, you paid for X, I don't believe that was medically necessary. I believe that was for your own benefit, it wasn't for the benefit of the patient. You could actually end up in litigation as well, where you're actually being sued by a family member. These are rights you also have to understand to know that you actually properly document the things once you actually start incurring and doing things on behalf of another. When I have a patient that comes to me and they start talking to me, I give the example of a hand. A hand has 5 fingers. If you can't get to the point that you're going to tell that this is a person that is in your top 5 of people that you trust, when you're stuck on the side of the road, this is the person that's going to come and take care of you. This is the person that would also call upon you. It's not the person you want to use. If they can't make your top 5, that's not the person you want to give the power to. Some people say, yeah, but I need to give it to somebody that's here, that's local. Well, the truth of the matter is, whether it be a power of attorney form or whether it be a healthcare surrogate, that person does not have to be local. The doctors are capable of getting somebody on the phone to have decisions being made. So just because a person is close to you, and that's meaning in driving proximity, that doesn't mean that's the person you have to choose. You want to get to your top 5 of people that you trust, people that will not sit down and take care of it. I love when I get calls from people saying, I gave so-and-so my power of attorney, and now my account is empty. I have a mortgage on my property that I never authorized. Realizing that the forms that you sign do give great amounts of power. People can take advantage of you. I've had examples of people having their nurses that are helping them or whatever else it is, getting the power of attorney form, and the next thing you know, that person's long gone, and you have nothing left. Choose the right people to take care of what it is that you need. I'm going to jump over a bunch of this, because I know I have a limited amount of time to speak. Let's get into the court documents and what you need to have done. As I talked in the beginning, I talked about the fact of a guardianship. A guardianship is actually a court proceeding. This is not somebody that was given a power of attorney. This is not somebody that you have designated and given powers to. This is actually a court making a determination what they think is in your best interest. I'm sure I can take a survey out here of everybody, and I don't think any single person is going to raise their hand saying that they want to have a court being the party to make the decision for you. That means a judge. That means that you're hiring expert witnesses. That means that you're bringing a bunch of people into a courthouse. In many cases, you're having a fight between family members. The fights between family members are amongst the most vicious. And you'd be amazed at how often this happens, even when somebody says, I really don't have that much. But not having that much doesn't mean that somebody doesn't want to fight for it. Somebody saying that I'm entitled to it. It's the case of the brother that has $1 million, and it's the case of the brother who was a former drug addict that's living at home with mom and dad. And mom and dad giving the house to the brother that was the former addict, saying, well, the millionaire doesn't need it. And then you see the family getting divided. Well, make sure these things are discussed and things are being done, and the documents are being created to take care of these things. Well, these are things that happen because the brother that came home was taking care of mom when she was old. Well, the other brother saying, yeah, but I'm the one that sat down and supported you. Well, this is the brother that she felt needed it. Conversations and discussions need to take place before family gets divided as well. How do you handle this? The best way really to handle it is by creating legal documents. And as I said, I'm going to tell you how to get many of these documents for free. The durable power of attorney is probably the most common and popular form that is out there. If you go and do a research online, this is the first form that's going to come out. What's the problem with this form? It's giving somebody medical decisions, and it's also giving people financial power. Well, you're creating that for a medical reason. Please don't use a durable power of attorney. We're going to talk about a healthcare surrogate form. That gives only medical decisions. That doesn't give the person the power to go to your bank, change the signer on your account, and take out your money. Go take out your 401k retirement plan. Go sit down and start getting all of your benefits being redirected to them. The durable power of attorney form is probably the most comprehensive document that you can get. It's nice if that person is the only person that you want to inherit your estate, and you're confident that that person is not going to clean you out and leave you with nothing, and say, well, let's get mom or dad or so-and-so qualified for Medicaid, and let's clean out their estate so that this money is saved. That's what that form is frequently used for when it's being abused. So think about what it is that you want to have. We can create powers of attorney form where you can say, I'm giving power over this and this, but not anything else. But unfortunately, for those type of forms, you really need to go to an attorney to get them. They're not generic forms that you can get for free. We can use solely a medical portion of a power of attorney. But that's still not the best form because somebody's going to see the words power of attorney and they're going to give them more power than just what the equivalent is of a healthcare surrogate form. A healthcare surrogate form says this is the person that I am choosing to make my medical decisions. This is not somebody that I'm giving the power to go into my bank accounts. This may not even be given to the person that I'm going to give the power to sit down and look over my medical records. It's merely making a medical decision. Well, in many cases, You may want to give somebody power to actually review the medical records, have an understanding of what's going on, but you need to sit down and give that person that power in order to get it. That person that's getting that power needs to actually have the document that gives them the support that says, give me the medical records. I have the power, here is my right, here is my legal document saying to give me those records. You want to have that in case you become incompetent, or you want to have that so that that person can sit down and do it for you so that you don't have to physically go do it yourself. So there are forms of a power of attorney form that can take care of healthcare decisions, but also give rights to medical records. But this is the stuff that we have to think about in advance when we're not too ill, and we can make rational decisions to take care of what exactly it is that we want to have. I've created power of attorney forms that give somebody merely the right to sell a house, transfer title to a car. It can be an exceptionally narrow document. I've created power of attorney forms that are 20 pages in length with paragraphs on them detailing every single power that I want to give, where I can sit down and say, yes, this power, no, that power, but then I can also sit down and actually modify the language in it as well. Because everybody has their own rights to privacy, and some people may not want people to have access to everything. There are certain powers that need to be specifically stated. There are powers that go well beyond HIPAA. Everybody in this world has probably heard about HIPAA that's here in Florida right now, but realize that there are also state protection of privacy rights that go beyond HIPAA for substance abuse records, HIV status. So those powers actually have to be specifically given if you want to have access to those type of documents. That's why every patient is different and every document needs to be customized, ideally. Now, the healthcare surrogate form is a form that if you have a pen and paper and you want to get one for free, I'm going to tell you how you can go get it right now. And it's very simple to remember. It's created by the Florida Bar. So if you were actually to do a Google search saying Florida Bar healthcare surrogate, you do that in your Google search, on the first thing that's going to come up is going to be a site that gets you to the Florida Bar. You're going to click on that. It's going to get you to a link. It's going to say Advanced Directives. Click on that. It will get you to the form for a power of attorney, not for a power of attorney form, but for a healthcare surrogate form and for a living will, and it costs you absolutely nothing. And it's created by the Florida Bar Health Law Section, written by some very bright lawyers, and the forms are there, and as I said, they're free. You don't have to go to a lawyer to have these forms created. The healthcare surrogate form, every single person should have. I've had it for over 25 years because that lawyer dragged me into the office to create the form. My wife has one. And yes, my wife has MS. That's also another reason why I'm here. So we want to sit down and find the ways to get you these forms so you can actually make the decisions and have the person that you want to make those decisions. The other thing that's important is a living will. Choose the person who will honor your wishes. But a living will, again, has to sit down and say what it is that you want to sit down and give the rights on, and whether you want to have life-sustaining devices or not have those life-sustaining devices. But you can sit down and you can get these forms, and I encourage every single one of you to do it now. You're capable of making it here. You have your sanity. You have your abilities to do it. Create these forms and have them, and choose the right person to do those powers for you. The person, the healthcare surrogate, does not have to be a relative. You can have your friend. I have many people from the MS organizations that I've met over the years, and they've given it to a very close friend of theirs that understands them, understands their wishes, and will comply with their wishes. Sometimes family members get too emotional, and they're sometimes the world's worst person to be one making your healthcare decisions. So this is the decision that comes to you, and only you, to make the decision as to who you want to give that power. Did I go too far? No. Advanced directives, that's not really your healthcare surrogate. Advanced directives are your living will. Do not resuscitate orders. Forms along those lines where you have to make your decision as to what you want to have done. Organ donation. All of these are things that you have the ability to sit down and make your rights to choose what it is that you want to be. Florida makes it very easy for organ donation. If you still have your Florida driver's license, you can put it on it. But if you don't have a driver's license and you need to sit down and make those decisions, these are forms that you can have to sit down and make those decisions consciously when you're ready to. These are not things that you want to sit down and just do, saying, okay, the lawyer told me I have to do it tomorrow. Well, I don't say you have to do it tomorrow. You don't have to do it today. You do want to actually spend the time to think about it, but you don't want to sit down and wait months to do it, because then you're going to forget and never get it done. And you're going to become one of those people that says, yeah, I should have done it when I was capable of it. Or I wish I had had it done. I've had power of attorney forms where I've been given to me by family members. Even some of my clients have given me the decision because I said, I know you will comply with what I want. So I've done it as a lawyer, I've done it as a family member, and it's an important decision to make sure that you have it and to give it to the person that you can trust. Also realize that the advanced directives in your healthcare surrogates can be changed at any point in time. You have the ability, 3 months later, I said, well, I'm not really that friendly with so-and-so. I had a big falling out with that person. I want to give it to somebody else. Well, if it was on your top 5, I don't think that would have happened. But if you make that decision, you always have the right to change it. The living will is another very simple thing that's in here. What is the living will designed for? It's saying, I don't want to have any life-sustaining devices that are given to me based upon a terminal condition, an end-stage condition, or a persistent vegetative state. You can have the right to choose which one of those things it is, because different people have different feelings towards each one of those. Do not resuscitate orders are another important thing to have an understanding of if you want or don't want. The importance of the writing is to sit down and actually create the powers, to give the right. Give the person the right that you want to give that right, understanding that that person that you're giving that power to is as much or as little as you want. And that's the best way that I can really tell it to you, is a legal document is no more than legal words being put onto a page and being executed in a fashion that's enforceable. But the language that's going to be in every one of these documents is something that you're going to be capable of understanding. If you can't understand what you're being asked to sign, you should not be signing that document. If somebody's bringing a document to you to sign, and it's not from an attorney that you have hired, you probably do not want to sign that form. Read the documents, get an explanation, and if somebody's giving you a document that you don't understand, hire an attorney. Getting these documents done really is not overly expensive. It's money well spent, because if something's being put in front of you, most likely it's not in your best interest. I can say honestly, at least once a month, I get a phone call from somebody who has been taken advantage of. These are the most depressing calls that I get into my office, because people have signed things not understanding what they're signing. There are times that I sit down and say, I can't assist you, because I'm also going to make sure that I'm the person having the conversation. Unfortunately, my office, I should say fortunately or unfortunately, my office is in Coral Gables. I do not speak Spanish. So when the clients come to me, if I'm not capable of having a conversation, I refer them to one of my friends who is fully bilingual that has the ability to explain the documents. If English is not that person's first language, they need to go to an attorney who can sit down and explain what those documents mean. Because unfortunately, once they sign the document, even if they didn't understand what they're signing, that document is going to be an enforceable document. And the person that has those powers is going to have the ability to utilize those powers. And yes, I have seen houses sold without the person's desire. I have seen accounts drained. So I get to see the worst of the worst. Part of the reason that I spoke with Stuart, probably at best about 4 years ago, was the first time when I had to give one of these speeches for somebody, I think it was over on the west coast of Florida. And the number of people in the room was a little bit larger at that time, and I had a lot of people in there that said, I had given up those powers. I didn't realize what it was that I had signed. But realize, even if you have given up those powers, you have the right to revoke those powers. So if you've already done it, don't get concerned unless you've already been taken advantage of. You have the ability to terminate the powers of anything that you've given, have new documents executed, and have those powers to be only what it is that you want to give. If you ever have questions, you can always get my email from Stuart. I respond pretty fast. Unfortunately, you guys are a lot further north than I am, so I can't really help you all, but I can also get you referrals to people that that can give you assistance in creating the documents that you need. But again, realize the most important two are the living will and the healthcare surrogate forms, and there's no reason for you to hire an attorney and pay an attorney money to get those things when you can get them from board-certified healthcare lawyers that have designed those forms, and they're available for free. And with that said, I'm here for any questions that you have.
Great. And the same thing will apply. First, let's thank Craig for coming up here today. Yay, yay, yay.
Yeah, this is really a question. About 4 years ago, an acquaintance and I has MS, but has cancer. I got a call from the hospital. I was to decide whether to pull a plug or not, and I had no idea she put me down as the person. You know, I had 24 hours to find her daughter, who was in the West Coast.
Well, once you are given that power, that means that person consciously made you the person, probably because they did not want their daughter to be the person to make the decision. Unfortunately, if you're giving somebody this power, you really should discuss it with the person so the person knows what your desire is. Unfortunately, there's not a legal requirement that before you're listed as the healthcare surrogate that you have to say, I accept that position. Once your power is given to you, most likely it's being given to you because the person says, I believe you were in a better position to know what I want than my own child. Yes.
Once I fill out the paperwork, to whom do I give it?
Most of the forms have a sheet on it to say that I'm sending it to 2 people. I would say the first person you want to send those forms to is your primary care physician, most likely what I call the MSologist for the people that are in this room, because that person should know who is the person that you want to make the decision. They should know that what your desire is for living wills, and they should know who your healthcare surrogate is so they can make the phone call to that person. Yes.
You've talked about people draining a person's account, the caregivers draining their accounts. What if, like, this is a real world situation. My mother's 92 years old. She's on oxygen. She's occasionally, typically she'll go to the hospital once or twice a year, comes home and ends up with a $1,200 to $1,800 bill. She has prepaid funeral arrangements, so I don't know if they can go after that. But what happens if she passes while she's in the hospital? What happens with those bills? If you're the caregiver and you're the power of attorney, are you responsible for those?
You are not personally responsible for anything unless you sign a document agreeing to be responsible for the debt.
Do they go after the funeral arrangements, or they can't touch that?
No, the prepaid funeral, that's paid for. That's not money that they can go after. But what they can go over is any money that's in that person's account.
Which isn't anything.
And if there's nothing in that account, there's nothing for you to worry about. But under Florida law, the only way that you can assume the debt of another person, and that's even if you're the personal representative, you're not assuming the debt, you have to sign a document saying that I agree to be personally responsible for the debt of another. So don't worry about somebody giving you a power of attorney form, meaning that it's going to make you personally responsible. No, it just means that you have the ability to use that power to take care of those things for them.
So any of the bills that come, you just ignore them.
You can sit down and send them a letter saying, I'm sorry, but there's no money in the account. There's nothing you can go after. And by the way, we're probably not even going to be opening up an estate for you to go after, which means that the hospital would then in turn would have to go open the estate as a debtor for the person.
Thank you. There was a day when the state pushed something called 5 wishes. Are they still doing that, and what do you think of it?
It's nothing that exists anymore. Honestly, that's even before my time, and I've been doing this for a long time. But the real thing is just making sure that you create the documents to express what your wishes are. And that's what all these forms are here for, is to explain to people what are your wishes. Who's going to make my medical decisions, and what are my wishes as far as a do not resuscitate order or life-sustaining devices in the event some tragedy happens.
Does these documents have to be signed in front of a notary?
No, they do not. Neither the living will or the healthcare surrogate form need to be signed in front of a notary. A power of attorney form does have to be signed in front of a notary.
Anybody else have a question?
Somebody up here did.
There.
My question is if you have a health directive that you made in Florida, and say you get sick and are incapacitated in another state, what rights do you have to enforce what your directive was?
What you sign here is enforceable in every one of the 50 states. I love when I have people come to me and it drives me crazy. Oh, I moved from New York to Aventura, and the attorney over there made me redo all of my documents. And I says, thank you. Just gave him a very nice Christmas present. Because she came to me because I moved from Aventura to Coral Gables. And I says, you don't need to do a codicil to your will because you moved from one place to another. If the will was enforceable when it was created, where it was created, every state has to honor it. That's just an attorney trying to take money. And unfortunately, there are too many of us that try to do things like that.
My question is, if you've already done the health care, you already drew up your will and you have the health care surrogate, where do those forms need to be?
Where somebody can obtain it, because if it's in your safety deposit box, it's not going to do very much good because they can't get into your safety deposit box without having a power of attorney that gives them the power to get into it. And then they would have to have that document. So the best place you want to have your living will and your healthcare surrogate forms is someplace accessible inside your house, giving them copies if you want to let them know that they're given that power. And you should be giving it to your physician so the physician understands who it is they should contact in the event you end up in the hospital, because chances are you're going to have on record that my doctor is Dr. So-and-so, and that doctor will know how to reach those relatives or friends. Still here, Stuart.
Oh, yeah. In the case of myself, I've signed up to donate my brain to the Rocky Mountain MS Center whenever I die or whatever. And so...
It's okay. We're all allowed to have those moments. I call it a senior moment. You can call it an MS moment. You can call it whenever you want. Don't worry. Yeah, you got to give her a second now. It's good that I can have this morbid conversation and still have people laughing. I like that.
So I've told my daughter, because she's the one, she is my
Your surrogate.
health care surrogate. But I haven't told my doctor. I mean, I told him I was doing this, but so like
Your doctor doesn't know that that you want your brain to go to a certain place. The doctor should know who your surrogate is so they can reach to your surrogate, and then they can probably take care of those details.
Yeah, because my daughter knows that she's supposed to. I have a card, and she's supposed to call that number so they can get the brain right away. But I also need to tell the doctor.
It's best to tell the doctor.
Okay.
But the most important part is for the doctor to know who your surrogate is.
Are those appointments exclusive, or can two people have the same power?
It's best to have, like, if you look at the healthcare surrogate form, it said this is my first person and this is the second person in the event that that person is unavailable.
Thank you.
Because what happens if you give that power to two people and then they have a difference in opinion? And yes, that does happen.
Thank you.
Any other questions? Let's thank Craig again.
Okay, just before I sign off, Google search Florida Bar Healthcare Surrogate Form. Please get the documents.
Thank you, Craig. Thank you.